Have you ever sent a text in anger, or maybe made a promise over WhatsApp? Well, today we're diving into whether those very messages can actually show up in a courtroom. Let's get right into it.
Seriously, just take a second and think about your own chats. All the plans you've made, the jokes, the arguments. Have you ever stopped to think, hey, could these words be read out loud in court? And more importantly, could they be used to help your case or to hurt it?
So the answer is a huge, unequivocal yes. They absolutely can. But, and you really need to hear this part, you can't just walk into court, whip out your phone, show a screenshot, and expect that to be the end of it. Oh no, it's way more complicated than that.
So let's zoom out for a second. Why are we even talking about this? Why have our digital messages suddenly become so incredibly important in the eyes of the law?
Well, it really comes down to the sheer scale of it all. In India, WhatsApp is more than just an app. It's practically a public utility. It's where business deals happen, where families connect, and where disputes play out. This makes it a goldmine of potential evidence for all sorts of cases, from civil suits to criminal trials.
Okay, so to understand how this works, we need to get familiar with a key legal term, electronic record. It sounds technical, but it's simple. Under Indian law, this basically covers any data sent or stored electronically. And yep, that means every single one of your WhatsApp messages, photos, and even those voice notes you send. But here's the thing. Just because your chat is an electronic record doesn't mean it's an automatic ticket into the courtroom. There's a really important rule that acts like a gatekeeper. It's called Section 65B of the Indian Evidence Act, and you can think of it as the golden rule for digital evidence.
So what does this golden rule demand? It lays out 4 basic conditions to prove the evidence is reliable. You have to show that the device, your phone, was used regularly, that the messages were sent as part of your normal everyday activity, that the phone was working fine, and crucially, that the copy you're presenting is a perfect, untouched replica of the original. You've got to satisfy all 4 of these.
So, how in the world do you prove all that? Well, it all comes down to one special piece of paper, the Section 65B certificate. This document is not just a formality. It is literally the key that unlocks the courtroom door for your WhatsApp evidence. Without it, that door is slammed shut.
And this slide really says it all. The difference is night and day. Without that certificate, your chats are inadmissible, worthless in court. But with the certificate, they become admissible evidence that can completely change the game. It's truly that black and white. Okay, so we get it. The certificate is crucial. But how do you actually do this? What are the practical steps you need to take to get your messages from your phone and properly in front of a judge? It really boils down to this 3-step path. Step 1, preserve. That means you have to secure the original device and make sure nothing is changed or deleted. Step 2, certify. Get that mandatory 65B certificate. And step 3, submit. You then present the printouts or digital copies along with that certificate to the court.
Now that first step, preservation, is super important. And let's be clear, a simple screenshot is pretty weak evidence. Why? Because everyone knows how easy they are to fake. The gold standard, the really strong evidence, is something called forensic imaging. That's when an expert creates an exact, verifiable copy of all the data on the device, making it incredibly difficult for the other side to challenge.
All right, so we've laid out the rules and the steps. But the real world is messy. So let's talk about some of the common traps people fall into and bust some myths about digital evidence. What's really interesting is that the rules have gotten stricter over time. If you look at this timeline, back in 2005, the courts were kind of flexible. But then a huge shift happened in 2014 with the Anwar PV case. The Supreme Court made the 65B certificate absolutely mandatory, and by 2020, they doubled down, making it crystal clear. No certificate, no evidence. Period. This leads us to a couple of major myths we need to bust. Myth number 1, any screenshot will do. As we've seen, that's just not true. Courts are very skeptical of them. Myth number 2, once I delete a message, it's gone forever. Nope, don't be so sure. Forensic experts have some pretty amazing tools and can often recover data you thought was completely erased. So, as you can probably tell, this whole process isn't exactly a walk in the park. You have to prove the messages weren't faked, deal with some complicated tech stuff, make sure your legal paperwork is perfect, and navigate some really tricky privacy issues. It's a lot to handle. So let's bring it all together. After going through the law, the process, and all the challenges, what does this actually mean for you, for me, for all of us who use WhatsApp every single day? Here's the bottom line.
Our digital chats aren't just disposable, casual conversations anymore. They create a digital footprint, a permanent record. Every single message you type and hit send on could, potentially, end up as official evidence in a court of law.
And that leaves us with one final question for you to think about. Now that you know the rules, now that you know the legal weight your words can carry, will you text differently?